Let's bring back in Bob Bianchi to discuss. And Bob, I found myself getting out of sorts and a little mean here on set during this the bond hearing, because the victim was 11 allegedly when it started, and I think she's absolutely a danger to the community because she's a sexual perpetrator. That's not going to change. That's not going to go away. That's my opinion. Tell us what you think about her potential release.
Judge, this is my case. It is from the great state of New Jersey, so I know it really well. Look, this is about as bad as you can get in terms of a sexual assault case. There are so many charges she's ultimately going to confront when this indictment comes down, in addition to the aggravated sexual assault. So anytime any adult has a sexual relationship with under the age of 13 in New Jersey, it becomes a first-degree crime, the most serious. You heard the prosecutor using this term, NERA. NERA stands for No Early Release Act, which means the judge can sentence up to 20 years with 85% before the person is even eligible for parole. That's just on one offense. The other sexual assault offenses that are different and can be consecutively sentenced is that she is a teacher, so she has another obligation under the sexual assault law not to have sexual relations, because you cannot consent when you are a teacher with regard to anyone under the age of 18 for sexual assault. The other charge she's facing is official misconduct, another whopping charge in the state of New Jersey that can be consecutively sentenced to 10 years with 5 years of parole and eligibility. Now, to the prosecutor's argument, because of all of these things, she is not presumptively entitled to be released. We do not have cash bail in New Jersey. We have a detention scoring system, and she's about as high as it can get. As you heard the prosecutor note, the probation department, the PSA report, which is a public safety assessment report, recommended denying her for a number of reasons, including the possibility of tampering with evidence. Now, I threw this, Judge, last point, to my former prosecutors that are on my team with the Bianchi Law Group, where we do criminal defense, and I'm like, any chance in your mind this person gets released? And they are, no way. Danielle, no way. Chris, no way. All these arguments multiple times that this happened, and all the lawyers in my office said that. Last thing, Judge, I had a case just like this. It's really fascinating. A boy abused by a teacher who somehow got the parents to agree to let the child live with her and sexually assaulted and abused him for many years. And I'll never forget the psychologist that said, when my client indicated, I couldn't make the distinction whether she was my mother, my lover, my teacher, and now in this case, now he's the father of a child, and the statistics show, psychologically speaking, boys who are sexually abused are going to even have a more difficult time recovering this higher incidence of mental health issues, higher incidence of abuse, and a higher incidence of depression and suicide. So I suspect this judge is going to keep her detained until her trial.
And at 13, he had a child, and he shouldn't have. This case makes me want to throw up.
Yeah, there's no question about it that it's ugly. But, Bob, I want you to explain to our viewers, due to bail reform in New Jersey, there is no cash bail. How do you navigate that? Some people may look at that and say, oh, that doesn't sound right, but it kind of works in New Jersey. Explain how it works and how you navigate it as a prosecutor.
I'm so glad you asked me that, Michael, because Jersey, I think, did it really the right way. And I'm not saying just because it's Jersey, but as a former prosecutor, listen, I had cases where people that could not make bail, like $200 bails, $50 bails, who wound up hanging in the criminal justice system in the county jail for 2 and 3 years on minor offenses that even if they were convicted, they wouldn't do any jail time. So we all recognize that there was an abuse there. But what other states have done with their quote-unquote bail reform that's different than Jersey, and why Jersey's works, is that in the scoring system that you heard the prosecutor refer to as the PSA, unlike New York, remember everybody was complaining all the offenders were being released and violent offenders were being released? One of the major scoring aspects of the New Jersey system is the danger that you represent to the community, the danger of reoffense, the seriousness of the offense. All of those things can be taken into consideration and are majorly weighted in the PSA system in Jersey. And that's why I think Jersey systems works. It uses the common sense that low-level offenders are released, and offenders like this that could tamper with evidence, that could flee, or that could re-victimize people, stay in.
Yeah, and the seriousness of the crime, Judge, was a big part of the state's argument.
Yeah, absolutely. All right, unfortunately, we're out of time, but we're going to be bringing you lots more. Thank you, Bob Bianchi, as always, for joining us. I understand you're sticking around.
Let's bring back in our guest, joining us to discuss this hour. Still with us, defense attorney and former head prosecutor Bob Bianchi. Well, Bob, what do you make of the defense's argument thus far? Basically saying, one of the, I was going to ask you about this, the strength of the case, how that plays into determination by the court. It's not listed in the statute as one of the things the court considers, but obviously it's an important consideration for the court. And he's saying, well, at this point, it's not quite as strong as it could be because they don't have any DNA evidence yet tested.
Mr. Tumulty's an excellent defense lawyer, very well respected. He's doing the best he can with the information he's got. At this hearing, the defendant is entitled to the establishment of probable cause. That's what the prosecutor very well set out there. And next, it goes into whether or not you should detain the individual as they're waiting for the pendency of the trials. We discussed in the last segment, Michael, there's a PSA score, a public safety assessment, and that assessment score came out and said that she should be detained. My experience as a prosecutor and now criminal defense lawyer, as you know from the previous segment we did, I queried my former prosecutor staff. All my lawyers were former prosecutors, said any possibility of somebody who's charged with a first-degree aggravated sexual assault because the person's under the age of 13, the victim, who was a teacher, which is a whole separate aggravated sexual assault charge, who actually fathered the child of an 11-year-old and had a relationship where I heard 416 separate assaults, manipulated that individual to actually live with her, and the damage that could be done, as the prosecutor aptly noted. Does anybody here think that this person is going to be released? Based upon everyone's experience, including my own, the answer is no. But as I noted in your last segment, and I just want to reiterate this, the one thing that I'm going to have here is a caveat. This is a female defendant. And unfortunately, in another case that I dealt with that was very similar to this, it seemed to me that since there was a boy that was the victim, the prosecutors, unfortunately, as well as I was on the defense side of this, as well as the judges, did not take the cases seriously. And we do see this happen at certain times. And if you could say, let's switch it right now, and she's not a she, but she's a he, and it's a middle-aged man that's there and is accused of this, could the result be different? I only throw that out there because by my estimation, this is about as bad a sexual assault case as you can get. She does represent a continuing danger to the community. It's not just students. And she's charged with offenses where she has a high likelihood of wanting to flee because she's going to be spending the rest of her life in jail. If there were any other case, in my opinion, in Jersey, she'd be detained.
Yeah, there's no question about it that that's where I think this is absolutely headed, or should head for sure. One of the ways that I think the prosecutor really laid this out well for the court was talking about going back to something that the victim himself said, that these two would have sex 2 times a week, and this occurred over the course of 4 years. And the prosecutor added it up to be something like 214, 216 sexual assaults. Speak to that and the way that argument was made, because that really hammers home how serious this is.
Yeah, see, that is a really good prosecutorial standpoint there. You're dealing with, at that point in time, a predator. Okay, you're not, I mean, look, 11 years, I don't think there's going to be many rational people that are going to say that a teacher should be having sexual relations with an 11-year-old, much less get pregnant by that person. But when you've done it 216 times, you have made a conscious decision over and over and over again to victimize this child. And like I said in the previous segment, she's got control. She's got authority over him. Our parents give their children to these institutions in locus parentis to stand in the stead of the child, and to make sure that the child is protected and to make sure the child is not harmed. And she took advantage of that position, got this kid to actually start living with her so she could rape him over 216 times. So it's really, like I said, about as bad as you get, because she used her position of trust in order to get her grooming this child, and then into this situation that this child will never, ever be able to get out from under emotionally, because you know what? He'll always be tethered, not just emotionally, not just mentally, but he's got a child with this person. It's as bad as it gets, Michael.
Yeah, it's nuts. And you know, as far as the defense side is concerned, you represent folks from a defense point of view now. What's the importance of trying to get your client out? We know that every client is entitled to consideration for bail, not entitled to bail, but consideration for release before their case goes to trial. They are innocent until proven guilty. But it also, from a practical standpoint, as a defense attorney, having a client out makes a big difference rather than having them in jail.
Huge difference. Listen, I mean, the lawyer is doing an excellent job and what he should be doing, and it's his reputation. She got a good lawyer. I mean, a lawyer is trying to give an alternative view to a judge to say that, look, she does not represent a danger. She didn't, great argument, she did not reach out to the family. She did not try to manipulate any witnesses when this first got exposed and she got fired from the job. She's got roots in the community, so she's not a flight risk. So he's doing all that. And the reason is, Michael, one, obviously, your client doesn't want to be spending time in the county jail getting day-for-day credit, which is, I can explain that at a later point in time, but it's not all the credit you should be getting. And you don't have access to your client. You can't give discovery to them. You can't go over discovery. They just can't pop into your office. Every time you need to have a consultation with them, you've got to go into the county jail, and maybe the jail's in lockdown or not, or the hours. So definitely it's easier on the defendant, and it exponentially increases your ability as a criminal defense lawyer to represent your client when they're out. And that is why he's trying to say, Judge, look, if you let her out, she is not going to reoffend. She is not going to be a problem. Put some strict restrictions on her.
All right, Bob, stand by. We're going to take a quick break for our guest. Still with us, defense attorney, former head prosecutor, Bob Bianchi. Bob, you got to be as shocked as I am. You were saying all along that she was going to be kept in. I agreed 100%. But obviously, the judge basically said the state failed to show that she was a danger or an ongoing risk.
You know, Michael, oh boy, the first thing I have to say that I noticed was, did you see how Mr. Tumulty, who, like I said, is an excellent lawyer, he looked like he was jumping out of his skin. He was fidgeting. He was trying to, he wants to do the happy dance, the high five. This guy knows he just pulled a massive rabbit out of a very small hat. And interesting to me, he made an argument, he's a good lawyer. He made an argument that this judge apparently did this with some 46-year-old man who was charged with a first-degree aggravated sexual assault. But you know what the difference between that 46-year-old man was and this person? He wasn't a teacher. He didn't commit rape 246 times approximately. He didn't commit acts of official misconduct. He didn't father a child with a person who's 11 to 13 years old. And even that lawyer admitted that the judge was courageous in the other case to release the person. I'm curious, and I'm going to ask my team this. I'd like to go around the state of New Jersey right now, Michael, and I'm just saying this rhetorically because I know the answer, to see how many people are charged with a single act of aggravated sexual assault with somebody under the age of 13 who's getting released. Now, the defense lawyer made good arguments, and those arguments prevailed at the end of the day, but I'm not saying the judge made the wrong argument. It's a 1-1. It's the lowest you get. I'm just saying in most jurisdictions of most courts with a single act with one defendant, they'd be still in my opinion.
I got to say, and I mentioned it before, one of the things that this attorney did, and you mentioned he was a well-respected, very good attorney, is by calling upon that previous case, it's his knowledge of the judge. And we always preach this to young attorneys, get to know the judges you're in front of. He knew that this judge had a good result with, again, you pointed out the differences, but similar charged case, and he had a good result. And as a matter of fact, I think, if I'm not mistaken, Bob, it was a guy that he had represented. I think he was in front of him in that case. So with that goodwill, his background, this particular attorney's respect in the court, I think he played on all those things very well.
You know what, Mike? You make a great point, and here's another thing. This is where we talk about tactics, courtroom tactics. It's not about law school. You don't have to be really smart. You just have to be intuitive. The prosecutor, in my opinion, respectfully, made a great argument for detention, but after the defense lawyer did a very good job making his argument, she should have come back in rebuttal like I did and say, here's the difference between the other guy, Judge, and this case, just like I did moments ago, and that may have made a difference. You never relent when the court asks you, in my opinion, if you want to counter an argument, if you think you could potentially lose it. I think it was a lost opportunity, respectfully.
Yeah, and I got to wonder if the DNA might have played into it, the fact that they had her arrested before they did the DNA testing. I wonder if the judge took that into consideration. He didn't mention that, but it's just a thought. All right, Bob Bianchi, thank you so much, as always, for being with us. A real pleasure. Really appreciate you having you on the show.